I'd like to bring this meeting to order. This is the Standing Committee on Public Safety and National Security, meeting number 42. We are being televised, and we have a large number of witnesses. We're going to allow them some time to make introductory comments. We have from the Rideauwood Addiction and Family Services Centre, Mr. James Budd, the Senior Director of Corporate Services. Point of order.
Mr. Chair, if I could ask the other individuals who are in the room to vacate the room so we can continue with the meeting.
Okay. All cameras have to be turned off except for the ones that have the permission to be on here.
And the people
please.
who are having other meetings, if they could move outside.
Okay, we'll continue with our meeting. We have from the Department of Justice, Mrs. Margaret Trottier, the Senior Analyst, the Drug Treatment Court Funding Program, and we'll probably start with her presentation. We also have from the Royal Ottawa Healthcare Group, Ms. Helen Ward, the Clinical Director, Forensic Services Chaplain from the Ontario Court of Justice, Honourable Madam Justice Heather E. Perkins-McVeigh.
She's not at the table.
She's not at the table yet? Oh. And from the Ministry of the Attorney General of Ontario, Mr. David Moffat, Crown Attorney, and the Edmonton Drug Treatment and Community Restoration Court, Mr. Doug Brady, the Director. I understand that the Honourable Madam Justice Heather Perkins-McVeigh is not here yet anyway. Okay, we have quite a long agenda today, and so I will ask if Ms. Margaret Trottier is ready to begin with her presentation, please. Go ahead, Madam.
Okay. Thank you. My name is Margaret Trottier, and I'm a Senior Policy Analyst with the Policy Implementation Directorate of Programs Branch within the Department of Justice. I am responsible for the Drug Treatment Court Funding Program. Recognizing the link between drug use and crime, the Drug Treatment Court Funding Program was established in 2005. It is a policy partnership between the Department of Justice and Health Canada, which enables federal justice and health officials to test horizontal approaches for addressing the challenges created by drug-addicted offenders in the criminal justice system. The objectives of the Drug Treatment Court Funding Program are to promote and strengthen the use of alternatives to incarceration for drug-addicted offenders, to build knowledge and awareness among criminal justice, health and social service practitioners, and the general public about drug treatment courts, and to collect information and data on the effectiveness of drug treatment courts in order to promote best practices. As a component of the National Anti-Drug Strategy Treatment Action Plan, the Drug Treatment Court Funding Program supports 6 drug treatment court pilots across Canada. Those are in Toronto, Vancouver, Edmonton, Winnipeg, Ottawa, and Regina, with an annual budget of $3.6 million. Drug treatment courts operate within the criminal justice system, combining judicial supervision with substance abuse treatment in a concerted effort to break the cycle of drug use and criminal recidivism for repeat offenders whose crimes are motivated by drug addiction. Persons with drug charges are not automatically referred to a drug court. Drug treatment courts, for example, will not accept violent accused or persons who are involved in commercial drug trafficking. If the accused has used a young person under the age of 18 in the commission of their offense, or if they are charged with a residential break and enter, they do not qualify to enter into a drug treatment court. Participation in the drug treatment court program includes court attendance of up to twice a week, random and frequent drug testing, and attendance in a treatment program. Attendance at court on a regular basis allows the participant to inform the court of his or her progress and allows the court to reward compliance, sanction non-compliance, or impose new conditions or interventions to help the participants break the cycle of crime and addiction. Drug treatment court clients continue to participate in the program, typically for more than a year, until they meet the criteria for graduation. To graduate, they must achieve a prescribed period of abstinence from drugs while abiding by all conditions and establishing stability in the community. Not all DTC participants graduate. Some will be terminated from the program for incurring new charges, for being dishonest with the court, for repeatedly not complying with conditions, or failing to attend treatment. Drug treatment courts are aimed at reducing the harm people cause to themselves and to others through their drug use, as well as reducing the risk that these individuals will continue to use drugs and thereby continue to come into conflict with the criminal justice system. The pilot sites supported by the Drug Treatment Court Funding Program require strong collaboration between legal and treatment professionals at the local level. The Drug Treatment Court Funding Program does not specify a model for the pilot sites to follow. As a result, each pilot site has its own unique characteristics, taking into account the needs of the offender population in that particular city. As mentioned, another objective of the Drug Treatment Court Funding Program is to provide the opportunity to build knowledge and awareness among stakeholders and the general population about drug treatment courts. Efforts in this regard have included support to the Canadian Association of Drug Court Professionals for national conferences in 2006 and 2008, as well as roundtable events in 2007 and 2009. We also support an electronic bulletin board that facilitates exchange of best practices and lessons learned among drug treatment courts in Canada. Finally, we are focusing efforts on national data collection as we implement the summative evaluation recommendations. As part of ongoing program management, Justice Canada is committed to further review and evaluation as we determine the effectiveness of this innovative approach to dealing with drug-addicted offenders in the criminal justice system. As the majority of pilot sites have been operating for less than 4 years, it's not possible at this time, based on the data available, to determine if drug treatment courts are the most appropriate criminal justice intervention for drug-addicted offenders, or if they are the most efficient or cost-effective way of dealing with substance abuse issues in the criminal justice system. The Minister of Justice has recently announced that Drug Treatment Court Funding Program will continue to provide funding support until March 31st, 2012 to the existing 6 drug treatment court pilot sites in an effort to continue to study the effectiveness of DTCs in Canada. That concludes my opening remarks on the Drug Treatment Court Funding Program, and I'd be happy to answer any questions.
Thank you very much. We'll go through all the presentations first before we open it up for questions and comments. I believe that Mr. Doug Brady will be the next presenter. Anytime you're ready, sir, go ahead.
Thank you. My name is Doug Brady, and I am the Executive Director of the Edmonton Drug Treatment and Community Restoration Court, as we are called, and also the Interim National Director for the Canadian Association of Drug Treatment Court Professionals. The Canadian Association of Drug Treatment Court Professionals is a recently incorporated organization dedicated to the development and sustainability of drug treatment courts in Canada, and to demonstrate this effectiveness through a comprehensive and consistent national evaluation. I'm going to tell you a little bit about the organization, or the origin of drug courts. The first drug court began in Dade County, Miami, in 1989 as a result of drug addicts repeatedly coming before the court system, also known as a revolving door system, and overburdening the jail system. What they found was that under the traditional court system, drug addicts continued to commit crime and never adequately dealt with their drug addiction. traditional treatment, court, and correctional methods did not show success. They found a solution by combining drug treatment with the structure and authority of a judge. Working as a team, they were able to effect lasting change in the lifestyle and behavior of drug court participants. Since 1989, drug courts have grown in the U.S. to over 2,369, and that's as of October 2009, of which over 1,250 are adult drug courts. In 2009, President Obama increased funding to the U.S. drug courts by 250% and is allocating $103 million in the coming year. This was preceded by a 50% increase the year before by the Bush administration. The first drug treatment court outside the United States began in December 1998 in Toronto. And since then, more than 27 programs have been implemented in 10 countries worldwide. Apart from the 6 federally funded drug treatment courts, there are 3 other drug treatment courts that operate independently, and they have their funding from various sources. That would include Durham, Calgary, and Moose Jaw, which has 1 person in their program at the present time. Drug treatment courts operate under what is called therapeutic justice. It is a program that provides intensive treatment and services for participants who need to get and remain clean and sober. We regularly randomly test for drug use, often once a week or more times depending on the person's need. We hold each participant accountable by the drug treatment court judge for meeting their obligations to the court, society, themselves, and their families. It requires participants to appear in court frequently so that the judge may review their progress and rewards participants for doing well or sanctions them when they do not live up to their obligations. How effective are drug treatment courts? Only 11.6% of those who complete drug treatment court program run into trouble again with the law. And that's a Canadian statistic from the UN Office on Drugs and Crime. Break-even analysis showed that to provide a net economic benefit to the wider society, only 8% of offenders seen by the courts would need to stop taking drugs for 5 years or more following the completion of their sentence, and only 14% in order to provide a net economic benefit to the criminal justice system. Many of our statistics come from the U.S. because they've been operating now for over 20 years. And so when I'm quoting some statistics from here on in, it would be from the U.S. statistics. But they have learned how drug courts work, and they're constantly reviving their programs and making sure that they get the best information out there. In February 2005, the Government Accountability Office issued its 3rd report on the effects of adult criminal drug courts. Although upfront costs for drug courts were generally higher than for probation, drug courts were found to be more cost-effective in the long run because they avoided law enforcement efforts, judicial case processing, and victimization resulting from future criminal activity. In Canada, those who participate in drug treatment courts would not be eligible for probation as a court disposition. The same extensive review of drug courts concluded that adult drug court programs substantially reduce crime by lowering rearrest and conviction rates among drug court graduates well after program completion. In recent years, researchers have concluded to uncover definite evidence for both the efficacy and cost-effectiveness of drug courts. The most rigorous and conservative estimate of the effect of any program is derived from meta-analysis in which scientists statistically average the effects of the program over numerous research studies. 4 independent meta-analyses have now concluded that drug courts significantly reduce crime rates on an average of approximately 7 to 14 percentage points. In some evaluations, the effects on crime are as high as 35 percentage points. Importantly, the effects were greatest for high-risk offenders who had more severe criminal histories and drug problems. This suggests that drug courts may be best suited for the most incorrigible and drug-addicted offenders who cannot be safely or effectively managed in the community or on standard probation. And some of the statistics from Canada include that over 50 to 60% of the crime is done by 15% of the offenders. Some of the facts from the National Association of Drug Treatment Court Professionals is that unless substance abuse addicted offenders are regularly supervised by a judge and held accountable, 70% drop out of treatment prematurely. Drug courts are 6 times more likely to keep offenders in treatment long enough for them to get better. For every dollar invested in drug court, taxpayers save as much as $3.36 in avoided criminal justice costs alone. When considering other cost offsets, such as savings from reduced victimization and healthcare service utilization, studies have shown benefits up to $12 for every dollar invested. Drug courts produce cost savings ranging from $4,000 to $12,000 per client. These cost savings reflect reduced prison costs, reduced revolving door arrests and trials, and reduced victimization. For methamphetamine-addicted people, drug courts increase treatment program graduation rates by nearly 80%. When compared to 8 other programs, drug courts quadrupled the number of abstinents from methamphetamine. Drug courts reduce methamphetamine use by more than 50% compared to outpatient treatment alone. And that's my presentation. I will be open to questions.
Thank you very much. Who would like to present next? Mr. Budd? Go ahead, sir.
Mesdames and Messieurs, ladies and gentlemen, honorable members, I'm very pleased to be able to address this committee on behalf of the Ottawa Drug Treatment Court. My name is James Budd, and I'm a Senior Director with Redawood Addiction and Family Services, who provides the treatment to the Ottawa Drug Treatment Court. We offer a very unusual program in drug treatment courts. It's a unique feature not only within the treatment world, but within the corrections world as well. Treatment is very intensive and very regular. Participants in the Ottawa Drug Treatment Court attend on a daily basis to the treatment center. They appear in court at least once a week, and at the beginning they appear twice a week before the judge. They're held accountable for any problems that they may have had in terms of their participation or attendance or other issues in the community, but they're also rewarded and encouraged for their successes in the program. The interaction with the judge is really a very, very key feature to drug treatment courts. They have literally a chat with the judge every week and talk about how they're doing. It helps to forge a whole new relationship with the criminal justice system. They start to see the courts as helpers instead of punishers. I'm going to keep my comments very brief because I suspect that you'll have a fair amount of questions for us, and perhaps I'll leave it at that.
Okay, thank you. Who would like to present next? Ms. Ward or Mr. Moffat? Okay, Mr. Moffat and then Ms. Ward. Okay, go ahead, sir.
Thank you. I just wanted to take the time to say thank you. I wanted to correct, I'm an assistant Crown attorney. I'm not a Crown attorney. And I'm a prosecutor. My nieces ask me what I do for a living, and I say I put people in jail. I have 6 years experience. I started in the States, in the U.S., in Colorado, known as a state with some mandatory minimums and stiff penalties. And I'm here if you have any questions about drug treatment courts. I am the provincial Crown attorney in the Ottawa Drug Treatment Program, and I'm here to tell you it works. And thank you.
Okay, thank you, Mr. Moffat. And Ms. Ward.
Thank you. My name is Dr. Helen Ward. I'm a psychiatrist, and I'm in charge of the forensic program at the Royal Ottawa Mental Health Centre, which is the local psychiatric facility here. And I'm also a member of the Ottawa Mental Health Court Organizing Committee, and I'm here to talk to you about mental health courts, and I think I'm the only one today to speak about this issue. Essentially, mental health courts came along subsequent to drug treatment courts when it was started to be realized that problem-solving courts had a role to play and that mental health could also be addressed by this manner. So we're a little bit further behind in terms of outcomes and in terms of structure. They started in the States. The first mental health court in Canada started in Toronto, and really in the last 3 to 4 years there's been a real profusion of mental health courts erupting across the country as pretty much every city and in some senses quite small centres have started to get involved with mental health. The reason for this is that there's become a recognition, of course, of the criminalization of the mentally ill and of the Penrose effect, which you're probably familiar with, the idea that there's really been a trans-institutionalization, that back in the 50s we had all these psychiatric beds and now we have all these correctional beds. As the psych beds have gone down, the correctional beds have gone up, and the same numbers of mentally ill are institutionalized, just in the wrong place. The idea behind mental health courts are to try to address some of these issues, and particularly mental health courts should recognize that but for the person's mental health condition, they wouldn't have come to the criminal justice system in the first place. That's the kind of person we're trying to treat in a mental health court. We're not trying to capture every criminal who claims a mental illness, but we are trying to capture people whose mental illness was really in some way a strong contributor to their being in trouble at all. One of the ways that this is done is by diversion, and that's one of the purposes of mental health courts. But as we've gone along, we've come to recognize that the Crown's offices and courts are actually pretty good at diversion on their own. They've been doing diversion for a long time. I mean, diversion of shoplifters who might have a depression doesn't need a mental health court for the most part. But there are more serious cases and more serious offenses where mental health has been involved, where the criminal code in terms of a Section 16 or a not criminally responsible offense doesn't apply, or a fitness issue doesn't apply, to fitness to stand trial issue, but there's still a serious mental illness that needs to be addressed. And these people may well not be eligible for diversion because they may have committed a level 2 offense. So they're not going to necessarily end up with a stay of their charges or anything like that. There's going to be some penalty, but there can be an improved outcome if they are connected with mental health services. So one of the big purposes is to connect people with mental health services. It's a real patchwork out there. There's some improvement, but it's very, very difficult for the mentally ill and the families of the mentally ill to get access to the services they need in the civil psychiatric system. And so they often end up in this funnel called a mental health court. Another thing that's important to consider, especially for the seriously mentally ill, is that they may not have much of an idea about why they're in court at all. And they may not have much of an idea about how the whole thing works, and they can often be very highly intimidated. They often come across defense attorneys who really don't have a good sense of how to communicate with them, or may not understand their problems, or may not understand the questions to ask them about their problems. And all of this plays a role in how they're treated by the courts. So as you probably know, people with a mental illness who are convicted for an offense actually end up serving more time than people without a mental illness convicted for the same offense. And this is probably for a few reasons. One of them is that the seriously mentally ill may not have supports. Another is that when they're in jail, they may end up with poor institutional behavior that ends up in them having the maximum sentence or being resentenced. So because there isn't really as big a movement yet with mental health courts, and because it's not as clearly a federal matter as the drug treatment courts, there's been a real diversity in what's sprung up across the country in terms of mental health courts. They tend to come up quite informally. For example, in Ottawa, we started our mental health court without any additional funding. We essentially basically focused our resources. So we took some resources that had been provided to the hospital to provide outreach clinics, and we started running an outreach clinic at the courthouse. The Canadian Mental Health Association had been paid by the province to put in outreach workers, and we kind of expanded the role of that intake worker. The Crown Attorney assigned a particular assistant Crown Attorney to the mental health court. So we all kind of basically pooled our resources and put them together in one court, but with no extra money. And that's fairly common across the country. People just saw that there was a need and started to do it. In Toronto, the model they run is really by using a lot of bail appearances, similar to what you've heard about drug treatment courts, where the accused appears in front of the judge very frequently, and there are court support workers based at the courthouse, and those people they did get extra funding for in order to help those people access resources in the community, and that's the model they use. In New Brunswick, there's a model that's very much a clear, they set up a program and the person signs on, they follow this program, at the end of this program they get X, Y, or Z outcome. That's similar to one of the very interesting courts, even though it's outside Canada, it's a very interesting court, the Brooklyn Court, which is a felony mental health court. So this is a court that offers people with a mental health condition who have committed a very serious offense a placement and treatment for their mental health rather than jail. And that's the kind of thing that we want to try to offer here when we can. In Ottawa, we very much run a court that's intentionally quite flexible. You don't have a lot of requirements to sign on, except the requirement that there be a mental health condition and that the mental health condition have contributed substantially to the offense. And you have to have some willingness to participate in some treatment. And then we basically take it from there. We try to engage people in treatment, and then we have special pretrials where people from all kinds of mental health agencies participate with the attorneys in deciding on the legal outcome. It may end up being a Section 810 or peace bond, but it also may end up being a conditional sentence served in their home and further probation, but this would have been less than what they would get otherwise. When we're looking at what makes up a mental health court, there are some good documents out there, and so I won't try and go through the whole thing, but I would say that you really do need people that are specialized. You have to have teams that have some familiarity and get some training. So Crown attorneys, ideally legal aid, duty counsel should have some special training. You want to make training available to across the board. You really need to have the treatment people engaged in the court. We actually, as I said, we run a clinic at the courthouse. People can see me and my team and start to get treatment from the courthouse. And you need to have a judiciary that are willing, of course, to consider these issues as well and who are educated. Funding's pretty important. You don't need a lot of funding, though, and as I've shown you, you can do a lot with pretty much no extra funding, but I think very small amounts of funding in terms of coordinators would really make a big difference across the country. In terms of outcomes, what we know about mental health court outcomes is less, of course, than with drug treatment courts, and basically what we know comes from the states. Justice Schneider, who runs the Toronto Mental Health Court, recently wrote a book on mental health courts, came out last year, and in that book he said really there aren't good outcomes yet, particularly from Canada, and I would concur. But there's some good preliminary information from the United States that would show that if you compare people's interaction with the criminal justice system in the year before they went into the mental health court versus the year after, that it reduces their arrest rate by 4 times, which is a significant improvement. It also would show that program completers are much less likely to recidivate than people who did not complete the program. There's also, of course, mental health outcomes. You can measure, and it's quite clear from our court, that there are improved mental health outcomes. People get better, they stay well, they get into treatment, they get into housing, and housing is often a very important component. And these people are much less likely to, end up in the mental health system, which is, of course, even more expensive than ending up. If they end up in an inpatient bed, it's even more expensive than ending up in corrections. It's not clear yet whether there are financial benefits. And one of the things you have to consider is that you are taking people from a corrections system and potentially shifting them to a mental health system, and of course both of those are still state funded. So, you know, really though it's about making sure people are getting the right treatment. And if people get the right treatment and get established on treatment, then they're going to stay well and stay out of hospital. But in my opinion, personally, there should be better, and of course we're a provincially operated treatment system, so it makes it difficult. There should be a better community treatment provisions in place in terms of legal provisions to treat the seriously mentally ill. Those would really help in terms of making mental health courts successful. Finally, what are the challenges? Well, you have to have buy-in. You have to have buy-in from Crown. You have to have buy-in from Defense Counsel. Many Defense Counsel kind of shy away from the mental health court because they can make pretty good deals on the side anyway with the Crown attorney of their choice in another court. So they don't always take people through a mental health court if they think that won't be of benefit. My colleagues aren't always pleased with me for going to mental health court because they think I'm case finding and bringing them more business. And you know what? I might be, but it's business they should be dealing with anyway. And it does put pressure on those people when my patients who I've picked up in mental health court show up in their emergency rooms and are now connected and with people who are advocating for them. It does make a difference in terms of who gets treated. So those would be my comments, and I can answer any questions later. Thank you.
Yeah. Thank you very much, Dr. Ward. That brings to the end our presentations, and we will begin with questions and comments with the official opposition of the Liberal Party. Mr. Holland, are you leading off? Go ahead, sir.
Thank you, Mr. Chair, and thank you to the witnesses. It was very informative. Wondered if I could start with Mr. Brady. You, I think, talked very clearly about the efficacy of the drug treatment courts. But there's a couple of things I wanted to know. First, for those cases that you referenced where it's been shown to be most effective, cases where there's a persistent problem where nothing else seems to be working, with the limited number of drug treatment courts we have right now, what's the gap between the need to have additional drug treatment courts, or drug courts rather, versus what we have? What's the unmet need in your estimation at this point in time?
Well, I guess I can speak for the Edmonton Drug Court, but the Edmonton Drug Court is a little different in the sense is that we're the only court in Canada that actually brokers out treatment. So we rely on the treatment providers that are out in the communities to provide the treatment for us. And so there's a real gap in finding treatment space. Right now we have 24 people in our program. We have 22 people on a waiting list trying to get into the program, and they're waiting in custody trying to get treatment beds, housing in some cases, and I think housing is generally a major concern across Canada. And so those are some of the things, the challenges that we face. I don't know if there's more that you wanted to ask on that.
Well, I guess in some of the additional challenges that you're facing, because I mean, we know that some 80% of inmates are facing addiction issues. And we know that I think one of the problems, and I'm interested in your reflections on, is a continuity of care as well, both before people turn down a dark path and commit a crime, the fact that there's a limited amount that's available in the community to them, and then after they come out of the system, maintaining that contact with a system that's going to help them stay on the rails, if you will. Can you speak to your experience in that and the importance of continuity of care and what your experience is in terms of what support is there in the community beyond just the time that they're spending in court or in prison?
Well, one of the things we know is that any treatment program under 90 days for drug-addicted offenders aren't very effective. And in Alberta, it's unfortunate that most of our programs are about 42 days long. And they come out of treatment, and usually residential treatment. About 70 to 80% of our people go through residential treatment to begin with. They come out and they have the high from getting out of treatment of, you know, I can do it and all sorts of things, and immediately they're facing challenges that they never knew that they were going to face. At that point in time, we deal very closely with them. We see them, our treatment team sees them once a week. The court is very important in attending once a week, at least once a week, keeping them honest by doing frequent and random urine tests to make sure that they're staying on board, rewarding them when they're doing well, getting them hooked up with 12-step programs, which is very important, getting them hooked up with relapse prevention programs in the community, getting them hooked up with other outpatient programming, trying to get them back on track, and also getting some of the things back in their lives that they lost, like ID, trying to get them hooked up with education. Some of these people have great potential, but they don't have much education. So we're trying to get them back into the educational so they can get back into the workforce.
So would it be fair to say that it's the exception and not the rule that kind of treatment, that what you're just describing, is being administered. In other words, that continuity of care, that support to make sure that the person is given the skill set that they need to not reoffend, not go and commit another crime, and not constantly be in and out of the system, that for most that they're not getting that today.
I would say that's true. Most people coming out of the jail system, of course, they come out of the jail system and there's nothing for them. In our system, this is where we're putting them, and we're programming and putting them into different programs right away. So they're busy when they come out of treatment. And generally, they go from jail to treatment and us. And we keep in contact them while they're in treatment. We try to meet any needs that they have while they're in treatment as well. So we try to really connect with them so that they know they have support out there in the community. They know they have an arm to lean on. They know that they can trust us. That sometimes takes us a little longer time, but those are the things that we do to get them back going and put a foundation underneath them so that when they finally graduate from our program, they have the skills that they can focus on their recovery, continued focus on their recovery, and also in other areas as well.
You indicated you might.
Your question goes very much straight to the heart of what drug treatment courts are about, in my opinion. First, I should make it clear, and just in case it's not, that the drug treatment court is really an alternative to incarceration. While the vast majority of our participants come to us from custody, and they may have an extensive history of incarceration, they're coming to us after a brief period. What is particularly beneficial about the drug treatment court program is that the participants receive treatment in the community in which they live. They learn to stay clean and avoid committing criminal acts in the community in which they live. They're not sent to an artificial environment or to an institution to do that. They learn how to refuse the drug associates they've been using with. They learn how to avoid them. They learn how to avoid those situations in their community.
If I could to Ms. Ward, I'm interested because we hear varying statistics on the prevalence of serious mental health issues within our prison system. Some that peg it as high as 20% for male inmates, 60% for female inmates. You referenced the American model with mental health treatment courts and its efficacy, what it's demonstrated. I'm wondering if you can compare the models that are being used in the U.S. to you referenced a couple of different models that are being used here in Canada. Is there a model that you think is working particularly well? And how do we contrast against the models being applied in the United States?
Yeah, I don't think you can really draw clear parallels with the United States because sentences are so much longer for what we would consider often relatively minor offenses in Canada. So obviously there's a much greater incentive in a court that says if you do this, you won't go to jail. There's much greater incentive for people than there may be in the mental health courts. I would say that I actually am not an advocate of a particular model. I think it's important that the model fit the community. Different communities have different strengths in terms of treatment, and you'll never make treatment and treatment options universal. So I think it's fairly important to allow particular communities to set up the models that work for them, but you have to give them guiding principles. And the principles really need to be that you've got specialized people, that you've got treatment available, that you have housing available when you need it, and that you have some way to ensure that participation is voluntary and that participation results in a better outcome than they would otherwise get. One of the criticisms of mental health courts has been that people sometimes are made to jump through more hoops than they would if they weren't mentally ill. So you really have to be careful in Canada not to do that, which is why I'm saying that I think the focus should be really on the level 2 offense rather than just the level 1 non-violent offenses. I think that there should be an emphasis on level 2 offenses because that's where you get more bang for your buck.
Thank you.
Time is up on that. We'll now move to the Bloc Québécois. Monsieur Menard, are you going to lead off?
Oui.
Yes. First of all, these drug treatment courts exist in Quebec. First question.
No. Okay. Est-ce que vous connaissez l'organisation?
Do you know an organization called Portage in Quebec?
I'm sorry, I'm not aware of it.
Yes.
Bon. Pourriez-vous comparer?
Would you be in a position to compare, I wouldn't know how to call them in French, the drug treatment courts in Quebec, or the drug treatment courts with what exists in Quebec, in other words, Portage?
My understanding of Portage, and we have had clients attend there previously, is that they're not a drug treatment court by the strict model. They are a treatment center that accept people who are in conflict with the law, which is something that is difficult. And I can't speak to Quebec, I'm sorry, but in Ontario it's very difficult for people who are in conflict with the law to get into addiction treatment until those matters have been resolved. My understanding is that Portage is one who will accept people who are in conflict with the law.
Bon, en fait, ce serait peut-être trop long de vous en parler.
Perhaps it would be too long to get into it, explain it, but Portage was not created based on the court concept, but it was created for individuals who have very serious drug addiction, alcohol addiction problems, specifically heroin. Generally, when I present them, I say, imagine Alcoholics Anonymous, but at a very, very high level. Of course, there's some people that have come in conflict with the law, or that have dealt with Portage, but some people had not yet come in conflict with the law. I realize the approach is completely different. I'd be curious to know this. I know that for these drug treatment courts, first of all, there have to be charges before the criminal courts.
Si vous me permettez, monsieur.
If you allow me, sir, I was a Crown Attorney substitute in Gatineau, or assistant, for almost 3 years. There's an advantage in Quebec in that attorneys not only manage these types of crimes, but we also deal with narcotics offenses and all prosecutions relating to the Controlled Drugs and Substances Act. So I do have some experience in Quebec. We don't have the advantage of having a drug treatment court in Quebec, and I say that because I don't have the French expression for it. So we have to find other ways to find diversion, some kind of diversion, as we do in the case of mental health issues. So you'll have conditional sentences. You'll find partners who are willing to take on some accused who have narcotics-related or controlled drug problems, so that we can find other solutions. So in a way, we're going. Mr. Moffat, I only have 7 minutes, so you know what Portage is, from what I gather. Yes. You know that there is. Portage works with, there are other organizations also that work to try to help people rehabilitate. Yes. A number of lawyers attempt to refer their clients to these sentences so that they can have better sentences, don't they? Yes. I didn't know the drug treatment court approach. Should I gather that one of the characteristics of these courts is that they start by criminal charges? The process starts that way. Yes, not only that way, but there has to be an application from a defense attorney that comes to that applies with us. And then you have to have a judge, says Mr. Minal. Yes. Quickly. In the types of illnesses you were referring to, the documentation you sent in, you refer to bipolar disorder. I must ask this. I thought that bipolar disorder was something that could be easily cured through lithium, and that the major problem for people who are bipolar is to try to convince them to continue with their treatment, because once they feel better or feel normal, they feel they don't need these drugs anymore, and then they fall back into their illness. Otherwise, if they do follow the course of treatment, they can live an exemplary life. You know, Pierre Pelado was bipolar. A number of great artists were as well. So when people arrive with this kind of an illness, it seems pretty straightforward. Just take your drugs.
Tell someone with bipolar illness just to take their medication, but it's difficult to actually have them do it when they don't have insight. And so one of the things that you put around them in the mental health court is support workers, housing. You help them solve some of the other stresses and problems. You help them develop an alliance and start to develop a sense that they can improve their lives, and then they start to include medications as part of this. I often will prescribe people medications that that help them in some other way, like helping their sleep, etc. And then gradually, as they get better, their insight will improve. You're quite right that many people with bipolar disorder do very, very well, but there's also a small group who it's difficult to treat. We can't get them to stay on their medications, and they often are using substances, and so there's a real vicious cycle there.
OK. Je crois que vous...
Yes, I understand that you don't take on people who are accused of drug trafficking. Yet, it seems to me that a number of high consumers, if you will, of drugs, the people that are highly addicted to drugs, end up getting involved in trafficking so that they can purchase their drugs. That level of addiction is a problem that you should, in fact, treat, no? 20 seconds for a very brief response. We do take people who are engaged in trafficking. The Crown has discretion to look on a case-by-case basis at the issue to see whether this person is trafficking for their own personal consumption or if it's a commercial trafficker. Then that person will be excluded from the program. Thank you. Mr. Davies, you have 7 minutes, please.
Well, I want to thank each and every one of you for appearing before us today, and more importantly, for, I think, breathing a really strong breath of fresh air into what can be a very difficult problem. I mean, it seems like what you're telling us is that there are progressive and innovative ways, alternatives to prison, that actually not only are better for the people coming in, but also actually have some success in treating the underlying causes. So I just want to thank you for the work you do. I guess my first question is probably my bad notes, but I just wanted to clarify, Ms. Trottier, if I understood correctly, you indicated that that funding has been increased to March 2012 for the existing 6 drug treatment courts. And I thought I heard you say that there was no real way to gauge the effectiveness of that program. Did I have that right?
Recently, we've completed the summative evaluation on the initial 4 years of the program, 2005 to 2009. The summative evaluation concluded that we still needed some more time to evaluate whether or not this is an effective or cost-efficient approach. Yeah.
Okay, now, if I could drill into that a little bit, are you looking to see whether it's effective or whether it's cost-effective or whether it's effective?
I think we're probably going, not probably, we will be looking at both. I think that there is an opportunity to determine whether or not it's cost-effective. But I think the other side of it, not all, when we're dealing with issues around high-needs clients, cost-effectiveness or just an efficient program or an effective program, you know, there'll be elements that we'll explore when it comes to cost issues. There'll be elements that we would explore around effectiveness as well.
Well, what I'm hearing from the rest of the testimony here, at least I'm getting a pretty broad swath that these programs, both mental health courts and drug treatment diversion programs, are very effective. And I'm just wondering if anybody wants to just comment on that and tell us whether or not we should be expanding this program to include more of these courts across the country.
Well, I can attest that the drug treatment courts across Canada have varying results, and I think that what Margaret alluding to, But we're seeing very promising results and encouraging results in moving forward. We're seeing a great cost saving, and I can speak an awful lot of Edmonton because that's where I'm from, because we did a social return on investment piece on our program evaluation, and for every dollar that we spent, it was $5.90 return on investment. Now, we also know that we've had success rates in Canada of up to 32%. Completion rates, I guess, is a better way to put it, because success is really hard to measure when you have people that maybe don't graduate from the program, but have benefit from the program and decided to opt out near the end of their term with the drug courts, and that happens across Canada because they have, for some reason, decided that they would now just want to get it over with and move on. And many of these people remain clean as well. But we would want them in the program longer, but they decided that they want to get out because it's not an easy program.
Sure. Mr. Budd, did you want to comment?
Yes. The people who come into drug treatment courts typically are some of the most disadvantaged people in society. They're very often homeless when they come in, and they are very high needs, and they're, because of their history, at quite high risk to reoffend. One of the difficulties of doing a national evaluation and coming to some kind of conclusive data is how different each court is, because as Dr. Ward expressed, they really are built upon community models and responding to the unique needs and structure of each community. I can say that in Ottawa, the average participant who comes into our program, we assess them very carefully before they come in and do some extensive interviews with them, uses on average $500 a day worth of drugs before coming into our program. All of this, of course, has to be supported by criminal activity. And you understand, of course, that you don't commit $500 worth of crime to buy $500 worth of drugs. The cost is much higher than that. We did some analysis within our program and found that in a one-year period, approximately $3 million in drugs were not consumed in our community. That doesn't even consider the crime required to support that that amount of consumption. So I think the courts are very effective. The other thing is, in terms of reducing criminal activity, our first year of operation, we operated differently. You have to remember, drug treatment courts have been running in Canada for about 3 years, the most recent funding agreement anyways, and we're learning as we go. In our first year, about 40-some% of our clients reoffended while being involved in the program. We increased the intensity. We brought in some criminal thinking and dropped that down to about 14%. It's gone down lower since. Now, you have to remember there's two types of reoffending, the one they get caught for and the one they don't get caught for. If somebody's using $500 a day, they're committing a criminal act every day. Many, many criminal acts. Spoke to one client recently who told me he would shoplift all day until the stores closed, and then he'd start breaking into cars. I like to think that any day a client is in drug treatment court and not using and committing crime is a good day and a benefit to our community.
Thank you. In terms of the mental health court, which I think is an excellent idea as well, I wanted to know if you could tell us, conversely, what is the effect of having mentally ill offenders in prison? I mean, we're talking about diverting them out of prison. What is the cost of having those people in prison, untreated or treated, as the case may be?
Yeah.
About 30 seconds.
All right, there are a few costs. I mean, one of them is that they actually cause more or are involved in more institutional issues, so that in fact you end up with increase in segregation, increasing altercations with guards, so sick time, injury time, etc. You end up with potential suicides. You end up with people who need drugs, quite expensive psychiatric medications while in the correctional facility, and probably more of them than if they were out. You also end up with people who come out without any treatment established, so they rapidly go back in. I mean, I've had a few people who I can't even get my hands on before they're back in again. So those are the kinds of things we really need to fix, because in the end you're ending with really increased days.
Thank you. Mr. Rathgaber for 7 minutes.
Thank you very much, Mr. Vice Chair, and thank you very much, all of you, for your excellent presentations today. Beginning with Ms. Trache, you indicated that not all of your participants are graduates, but you didn't tell us what percentage are, and I was wondering if you have that statistic.
As mentioned, the national evaluation is challenging in that we bring together the results from the number of different programs across the country. What the current statistics show is that we have a range between 6% and 36% graduation rates at the various programs. So there's an obvious need for us to collect better data to better understand, what the graduation rates are.
Mr. Brady, do you keep statistics from the Edmonton program?
Yes, I do.
Of graduates? What's your rate?
We have when you take a look at when we did our original evaluation, it was 27.5%, and that has increased now to 32% graduation rate. And many of the graduates, well, all of the graduates come back and see us, but there are people that didn't graduate that come back to us as well, and even after they've been removed from the program, they come back and come back to us and tell us how well they're doing.
Sure. So for the 68% or so that don't graduate, they're ultimately sentenced. I take it. Their sentences are not well, their sentences are initially suspended, but if they don't make it through the program, ultimately there is some disposition, a fine, probation, perhaps a custodial sentence. Is my understanding correct?
That's correct. And I think across Canada, most of the people that come to drug courts would be receiving a custodial sentence. So they would return to the original sentence that was set out at the beginning. Usually that's an early case resolution in our provinces, that they would be receiving somewhere between 18 months and 3 years in jail. And that varies up to 2 years less a day, I think, in Ottawa. And so that varies across the Canada, but they would have their original sentence that they would be stuck with.
Now, Mr. Brady, I have to challenge you on one of your stats. You said 11.6 of your graduates are not recidivists. I'm just curious as to how you measure that, because unless you're tracking them all the way until their end of their life, there's no real way of coming up with that stat. Is that 1 year out? Is that 2 year out? Where does that 11.6% come from?
I've got that out of the UN Office on Drugs and Crime. So that's 11.6% of those who complete drug treatment court programs run into trouble with the law again. And of course, you can't measure it, and I agree. It's probably 2 years out, I would think.
Okay. Do you have a way of finding out for me?
I will check that out and get it back to you.
I should disclose that I spent a half day with Mr. Brady and Judge Wong at the Edmonton Drug Court, and it was a very fascinating afternoon. And I learned a lot, and I encourage all members to do so, especially since there is one in Ottawa. Now, with Ms. Trache, you talked about funding for the program being extended to 2012. Now, C-15, which has been stuck in the Senate for about 6 months, creates some provisions with respect to expanded role for drug treatment courts. We haven't talked about that, and I'm assuming you know what those are and what it means for the program should C-15 ever become law. And I was wondering if you could educate the group on those provisions.
Within C-15, there is an exemption for individuals to avoid the mandatory minimum sentences if they are accepted into a treatment program. And I think that that treatment element of the MMP legislation is twofold. It does make specific reference to drug treatment courts, but it also makes reference to drug treatment generally. And so it would be up to the provincial attorneys general to determine what other levels of treatment would be appropriate in that context.
I'm assuming I must be close.
We've got another 3 minutes.
Sorry?
3 minutes.
Oh, really? Oh. Getting back to Mr. Brady and my summer day in July. I found it very, very fascinating, and I have a legal background, and I'm used to more adversarial legal context, and I think that members of this group can probably appreciate my adversarial nature. And of course, it's quite different. And the word restorative, quite frankly, threw me off, because when I think of restorative and justice, they're almost oxymoronic, especially for an old school guy like me. So I was wondering what, if anything, you or your counterpart from Ottawa, what do you do to market your court? Because I do agree that anecdotally, at least, there are many, many success stories. But I mean, I was not familiar with your program, and I practiced law in Edmonton for 17 years. What do you do, or what can you do to market your program, to convince funders like Parliament and members of the bar associations and to buy in, as Dr. Ward suggested?
Well, we do get out in the community quite often. In fact, one year I got out 52 times in 1 year, so that means I'm getting out an average of once a week. We go to speak to different organizations. We go to speak to universities, colleges. We've spoken at the Criminal Trial Lawyers Association. The Alberta Criminal Justice Association had an entire day just on drug courts for Alberta drug courts in Red Deer in October. We go out to probation officer conferences. We've gone out anywhere we can go. We go out, and we take participants with us. We take graduates with us, because our graduates are very supportive of our program, and they continue to work with us through the alumni group. We have barbecues. We do all sorts of different things with them, which I won't get into.
We're down to about 30 seconds. Your program, the participants attend weekly, correct?
Pardon me?
Your participants attend weekly.
Once a week.
And Mr. Buddy, did I hear you correctly that initially they attend daily?
Twice per week.
Twice a week.
They attend our treatment. They attend our treatments. Sorry. They attend our treatment center daily, and they attend court twice per week.
Thank you.
Can I add just one thing finally in response to your question?
In 15 seconds, yes.
15 seconds. The other thing we do, we've formed an association of courts across Canada. We have incorporated, and we've elected Mr. Doug Brady as our spokesperson for it. That's our other way of getting the message out.
Thank you.
Mr. Kennedy, for 5 minutes, moving on to the second round.
Thank you, Mr. Vice Chair. Thank you all for coming and being here. Obviously, I support both courts, and we're here today to see what we can do to try to improve things. So I will first focus on mental health. And Dr. Ward, the most concerning thing I've heard today from anyone is one of your initial comments that the corrections, the persons who are incarcerated have increased as hospital beds have gone down. So I'd like to discuss that first and to find out from you what might, if you have this expertise, what might be done to reverse that and to get the system back on track really the way it should be. And it could be as simple as saying we need X number more beds, but I assume there's a little more to it than that.
Well, I wouldn't get very far to say we need X number more beds. I do think that there is a disproportionate money put into mental health as opposed to other types of health, and the Mental Health Commission of Canada, I think, has been fairly clear about that. You know, that's fairly well established. The issue about trans-institutionalization is also pretty well accepted, that is what has occurred. What we need, I think, and the Mental Health Commission has started to look at this, that we need more housing for people with mental illness. We need more affordable housing for people with mental illness. You can't put treatment in place in communities unless you have proper housing. And so that's what we really don't have. I mean, if you don't want people to be in hospital beds, that's fine, but I can't keep people well when they're in rooming houses full of drugs or in shelters where they have to be out throughout the day. So that's probably one of the main things that could be done, is housing programs specifically targeted at the mentally ill. And then the other thing would be looking at funding or models that would encourage mental health practitioners, including physicians, to treat mentally ill people. I mean, there's really no incentive to try to help this population when pretty much any psychiatrist in the country could close their practice tomorrow and be living comfortably. So, you know, you need to create incentives. Sorry, I'm a little blunt. You need to be creating incentives for us to work with this population other than our own values.
Okay. And do you have studies or written proposals that are very specific in terms of what you might suggest should be implemented for both affordable housing?
I don't know that I can give you specifics. There are projects out there. There are models out there already. Certainly on a provincial level, there is housing for the mentally ill out there, and there are, for example, there are safe beds in Ontario which are designed as crisis beds for people with mental illness involved with the justice system. So those things exist. There are just not enough of them. So, you know, I'm not sure how much of a study needs to take place. More specifically with mental health courts, though, we don't have outcomes. And that's because there's been no money targeted towards outcomes. We can all come at it with our clinical resources, but we don't bring, you know, every mental health or health organization has been slashed to the bone. So we don't have a lot of analysts sitting around ready to do studies. So we need to be able to, those are the things that probably should be funded here.
Okay. I have 4 different points in terms of the mental health courts before I move to the drug treatment courts if I have time. First, the Crown acts as the gatekeeper.
Yes.
The Crown decides whether somebody goes into the mental health court?
Yes, I mean, they do, but usually there's assistance from mental health professionals as to whether or not that person should be there. So in Ottawa, we screen people who have been arrested by police and who've been identified as having a potential mental health issue. And we also offer an out-of-custody clinic which can also screen, so that can assist the Crown.
Okay, well, I've just been told I have 1 minute, so I'm going to go to
Sorry.
Point number 3. You mentioned something about, during your presentation, better community legal provisions needed. That's what I wrote down. Can you just describe in full what you meant?
Well, there are different provincial things for community treatment, civil orders to get someone with a mental illness who needs treatment but doesn't recognize that they need treatment to remain in treatment. This is usually for people with schizophrenia or related illnesses who need antipsychotic medications. They can often be delivered injectably every 2 weeks. But if they exist, most of the community treatment provisions are weighted towards the rights of the person with the illness and not weighted very well towards the person's family's interests or the people who actually can see that the person's ill, or in fact the community if the person has been committing offences against the community.
Okay, now Mr. McKenzie for 5 minutes.
Thank you, Chair, and thank you to the panel members here today. I've got so many questions. I wish we could have each of you for 2 hours. A couple of things have arisen, I suppose, over the last few years, particularly with drugs. And methadone is an area that is quite interesting because it seems that opiates being legally prescribed have taken off in leaps and bounds. And as a result, not only the legal use of them, but the illegal use or the improper use has spurred all kinds of methadone clinics in our communities. And what I'd really like to know is, do you see any improvement with those people addicted to opiates in the methadone, or do we just trade the opiates for methadone and it goes on forever?
Thank you. No, we see significant improvement with people participating in methadone maintenance programs. It is medically monitored. It's prescribed in a setting where they come into daily contact with service providers. It does not result in the same type of high, if you will, that street opiates do. And you are correct, we are seeing a lot of participants who are addicted to illegally obtained prescription medication. For us, methadone maintenance has been a very successful route for many of our participants.
Okay.
I just have one comment in regarding that, is that we don't have many in our program. I know Vancouver has quite a few, and I don't know how many James does in Ottawa. We have a couple in our program, and we have found success with them as well. But it is a lifelong drug that they're going to be on with methadone, because it is harder to get off than any other drug. But it's very much similar to something like an insulin for a diabetic. So it's something, once they're on it for a lifetime. So.
Okay. Mr. Moffat, I appreciated Mr. Canya's questioning there with respect to the Crown attorneys, but certainly it's been my observation over the years that Crown attorneys and the police will collectively work together to find a solution without the court having to order it. And I guess my question to you would be, as a Crown attorney, do you see the programs as being far more effective by people going into them in a voluntary basis than having to be ordered by the courts even?
If you ask me in my experience, I'm now going on to year 7 as a prosecutor in various different jurisdictions, but the follow-through that you have in court and the ability for the court to come to court twice a week now in Ottawa, we might be going to once a week, but once a week, twice a week, and that follow-through and getting them hooked up in that intensive way with treatment, while at the same time having that sentence hanging over their heads, it seems to be working, and certainly I would think that if people went voluntarily on their own, and we talk about on their own to in treatment, that works as well. But then the problem is always they go to in treatment, then they come back into the community from where they came from, and they haven't gotten those skills to how to not use. The advantage of drug treatment court in Ottawa, for instance, is they're axed on teaching people not to use in the community where they're going back to at the end of their sentence.
I guess what you're saying is if they're in the court system, there's an incentive for them to take part in the programs, right?
Oh, absolutely. And the more severe the sentence they're looking at, the more incentive they have. Absolutely.
Thank you. Dr. Ward, as the study is, in mental health and addictions, and certainly seems, I think, to most of us that the custodial system in the justice system has taken over a role that it was never intended to do, and that people with mental health issues are ending up in custody that society has somehow missed. Is there something, the magic bullet out there, that we should be looking at to try and get that fixed sooner?
I still think it comes down to giving us stronger tools. We need to be able to enforce treatment for people as a civil measure, particularly if someone has been involved in the criminal justice system, and that may take a lot of twists and turns legally, because ordering treatment for someone is a very serious thing to do legally. But honestly, that's what we need to be able to do.
Thank you.
Merci. Maintenant, Ms.
Thank you. Ms. Mourani, 5 minutes on the third round. Thank you. Thank you, Mr. Chairman. Welcome, everyone. Thank you for being here. I have a few small questions. Regarding the mental health court, are there several in Canada, or is there only one in Ottawa?
There are many, many mental health courts in Canada. There are probably 8 or 10 in Ontario, and they go right across the country. There's one in Montreal. They recently came to visit us here. I'm sure there are more in Quebec, but I'm not aware of them.
Okay. All right. In the document we received, we hear that these courts are essentially responsible for offenses that would have to justify a person being removed from the regular justice system, and it addresses a certain type of crime relating to mental health. What exactly would be the offenses that you would accept compared to, say, someone for whom it's been established the person has a mental health problem, if the person has committed theft or has sold drugs or has killed someone? I mean, what is the limit? Why would a person be treated under a mental health court rather than to be deferred to a regular court?
I think that again, this is probably my personal opinion, but The uses for a mental health court would be in areas that wouldn't traditionally be considered to be divertible. For example, domestic assault. It's very, very common in our court that we would see a couple, often they both have mental health issues, they've been living together, there may have been previous incidents, the police have been called, and the person, even though they were obviously ill, was arrested. They weren't hospitalized, perhaps because it didn't work before. And now we have someone who, in fact, needs special provisions, because one of the things, in fact, both partners want is for the person to be back in the home, but we need to be able to make sure that their mental health is treated and monitored. So that would be a good example of the kind of thing a mental health court would do that another court wouldn't necessarily be willing to do.
All right. Do you mean by that as well that this type of court treats the, how could you say, the most minor cases that can be dealt with in the community, first of all, before you're talking about mental health problems?
Yes, I mean, in terms of mental health problems, are you asking the type of mental health problems that we deal with?
No, perhaps I'm mistaken, but I need some clarification on this. I get the impression that these types of courts, yes, they deal with people who have a mental health problem, but people who have committed minor crimes and not minor offenses and not serious offenses, serious crimes like murder, really vicious crimes, pedophilia, that type of thing.
We wouldn't deal directly with those crimes in terms of a positive legal outcome, but we might deal with those crimes in the court. There's a provision, of course, for someone to be assessed for criminal responsibility for all severities of offenses. So my program would assess someone who'd committed murder if the court ordered an assessment, and would go back and bring provisions. But if the person isn't NCR, there's not going to be a diversion, because there's minimum sentences involved, etc. It makes no sense for it to stay in mental health court then. For things like pedophilia, again, our program does do assessments for the court of people with pedophilia, but it doesn't need a mental health court to then apply those recommendations or sentencing issues or risk assessments. So it's really the more serious things. There are already fairly good mechanisms in place. It's for the less serious, the level 2 offenses where there's assault with a weapon, perhaps criminal harassment, threats. Those are the things that we're trying to, that there's a gap in trying to address.
From what I gather, the same would apply for the drug treatment courts. In other words, it's minor offenses that would be dealt with under these court systems. It depends. In Calgary, the courts take people who are facing a 1 to 5 year sentence or to 3 year sentence. In Ottawa, eligibility is limited to people who have a sentence that would be less than 2 years or 2 years less a day. It depends on the court, but generally, yes, it would be considered more minor. But in Vancouver and Winnipeg, recently, they've found that they've had more success with people who've had longer terms or facing longer terms of sentence. It had to do with Mr. McKenzie's point. The more the sentence is lengthy, the more they're motivated. Thank you very much. Mr. Norlock, 5 minutes.
Well, my thanks to the witness panel. We're certainly learning a lot about the effectiveness and efficiencies of your various programs, but I was intrigued when I believe it was Dr. Ward indicated that her work or her collaboration with the Mental Health Commission was of great assistance, and I wonder if you could explain how you work with the Mental Health Commission.
Well, actually, I refer to their work, but I'm not working with them directly. Okay. Some of my colleagues are, as chairs. What I was doing was commending the work of the Mental Health Commission. I think they have it right in terms of looking at stigma and in terms of looking at housing first as some of the preliminary work that they're doing.
Does any of the preliminary work from the Commission, does it have a relationship to the forensic side of the treatment of mental health?
Yes, there's a law and mental health committee as part of the Mental Health Commission, and I know they're looking at, they've put out a call for proposals to evaluate certain areas of the mental health and justice system, but it was a pretty big call for proposal. So they're not really looking at it at the micro level yet, and I haven't seen anything. And of course, they don't have a lot of money themselves to implement programs. They're more looking at.
I believe it was in the 2008 budget, 110 million over 5 years, I believe. But it's good that we've got to start and we can build on that. My next question would, I guess, Dr. Ward, you can share it with perhaps some of the others, but it has to do with mental illness, and in particular, in my experience, primarily in Ontario, but in our travels recently across Canada, in various provinces, of course, each province has its own mental health act. And I'm wondering if you or any of the other witnesses have heard where perhaps there are issues concerning the Mental Health Act as they relate to both treatments and incarceration and the combination of both of them, and how, and your suggestion to us, because we're looking for answers as to how we can make that work in a federal system, being that because the federal system is pan-Canadian, and we actually have 10 provinces and territories, each with their own Mental Health Act. I wonder if you could comment on that.
I wish I had something brilliant to suggest. I don't think I can really give direction at this point in time. I think it is important to have some minimums, and if it comes from looking at crime federally, then maybe it can be transmitted that way through requirements from the courts. But I don't know how you're going to touch the mental health acts of the provinces. I think that's part of the problem.
Thank you. I wonder if Mr. Moffat has had any experiences in that regard, the differences in jurisdictions as they relate to Mental Health Act and the court system.
With apologies, I've dealt with a couple of committal issues where I've had to advise police on what they can do with civil commitments, but I really don't have enough experience to be able to speak to a difference.
Well, thank you very much. I think my next question actually was to do with that, but Dr. Ward could comment. One of my personal preference, and the committee's yet to make recommendations, was the fact that in some of the jurisdictions, they form partnerships with academia. I'm thinking in particular in Saskatoon, we went there and they actually changed the focus from a custodial or from a prison to more of a mental health, more of a hospital. And there seemed to be some successes there. So they partnered with the province, they partnered with academia, they partnered with other healthcare professionals. I wonder if you could comment on your experiences surrounding that, so that we can formulate a good report.
I think it is really important to have those links. You're talking about FPC in Saskatoon, the forensic. Yeah, I mean that's a real model. I mean you have to be able to get money from different sources to make this work. Is the bottom line. So you have to be able to encourage that collaboration. We see it here. We're running projects on a smaller level for housing for people involved in the not criminally responsible system, and the provincial government has mandated evaluation from the University of Ottawa and has our involvement as well as community agency involvement. So I think that is very important.
In Saskatoon, we noticed, of course, across...
Sorry, Mr. Norlock. There's another round coming up in just a moment, but right now I'm going to go to Mr. Oliphant for 5 minutes.
Thank you, Mr. Chair, and thank you to all our witnesses. Probably unlike Mr. Rathgaber, I think restorative and justice are actually intimately bound, and I think you're probably getting that these days too. I would say that justice without restoration is not justice. So I'm glad you are doing what you're doing. One of our witnesses that we saw a few weeks ago echoed the thought that Dr. Ward had around the criminalization of mental health, but also talked about prison having become a risk factor for mental health and addictions. So the actual incarceration actually worsens the situation. I wondered if anybody wanted to comment on that quote that was given to us.
I certainly would see it anecdotally that often it interrupts a course of treatment, and people are also exposed to environments that worsen their mental health. So they come out of it often untreated and in a worse psychosis or a worse depression than they were previously. They may have been exposed to, they may have become criminalized unintentionally. I mean, I see all of that anecdotally.
So I guess what we're trying to do is look at mental health in our prisons, but keeping them out of prison is probably the best step if we can do that.
Well, yes, and that's why I emphasize that we should really be focusing on people who, but for their mental health, wouldn't be in there. And that isn't everyone, but it's important.
Mr. Budd?
Yes, I'm sorry I can't cite the specific authors, but there is a body of literature referring to corrections that people who, the more frequently they come in contact with the criminal justice system, they become in effect criminalized. And if people are coming in contact with the system because of their addiction or because of their mental health, there's a very good likelihood that that will continue to become worse in the future.
My experience actually with addiction started at Rita Wood about 25 years ago in a training program that I took there for clergy to help us understand addictions. And in those 25 years, my thinking has changed somewhat from what I learned at Rita Wood into more understanding of harm reduction as well as abstinence. And I'm wondering, most of what I've been hearing today has to do with abstinence, and I'm wondering where you are at in your thinking on harm reduction.
Well, I'd like to comment on that from the point of view of mental health. With the mental health courts, it hasn't been said yet, but the proportion of our clients in the mental health courts that have addictions are probably about 80%. But we're nowhere near expecting them to go into abstinence-based programs. And in fact, best practices in concurrent disorders, which is mental health and addiction, suggests that harm reduction is the way to go. So we rely on agencies, in our case, the Canadian Mental Health Association, that offer harm reduction programs, and we find it a fairly successful model for our particular clients.
I would like to say that in order to ultimately complete the drug treatment court at the highest level, abstinence is required. However, along the way, we work with people from where they're starting. It's important to understand, and it seems odd to people at first, but participants in drug treatment court are not sanctioned by the court for drug use. They may be sanctioned for dishonesty about them, but we understand that they have many, many years with this problem and that this is an ongoing process.
1 minute, 30 seconds, good. I'm actually quite familiar and have been with drug treatment courts. That's something I know a fair amount about. Mental health courts is new to me. And I just need a little bit more. I know that we have and it's the government still calling it a pilot project with the 6 drug treatment courts. Started in 1998 or 1999 in Toronto. So we had some experience. The mental health courts, what's the funding arrangement? I mean, how does that work? And like the government has said they'll keep funding on the drug treatment courts till 2012. Where are we at with mental health courts?
Well, the short story is there isn't one, and the main difference being that the Controlled Drugs and Substances Act is federal, so it makes it much easier, whereas none of the mental health stuff really comes in there. So it's quite ad hoc, although I'm starting to see signs that at a provincial level, I mean, recently Ontario appointed a deputy crown attorney for mental health, and they're looking at proposals. So I expect to start seeing hopefully money, but I'm not holding my breath, but at least proposals or standardization at the provincial level.
Perhaps we could start with a recommendation from this committee that mental health courts should be part of a funding plan to help mental health in prisons.
Yeah, and it's the whole cross-ministry thing at a provincial level. There's so many ministries involved, and it makes it very difficult for anyone to step up to the plate.
Thank you very much. Mr. McColman for 5 minutes.
Thank you, Chair, and thank you very much for being here. It's been a great learning session from, I think, all committee members' points of view. I just want to kind of do a little bit of further exploration and perhaps wrap up on the issues of outreach, because certainly you've reinforced what we've heard a lot from a lot of people, and on a couple of levels. I know my colleague was talking about post-secondary institutions and such, and some of the most successful partnerships happen that way. And I think, Dr. Ward, you referred to the challenges that are faced, and we've heard of these challenges of retaining and actually keeping people working in the system, keeping professionals in the system. If there were anything you could recommend in terms of how we do that, how we bring new professionals like yourself and others in the professions to come in and to be part and to work within the correctional system, what would those recommendations be?
I think it's important to get behind anti-stigma measures, and I would also be looking at curriculums in various training programs and what they, for social workers, for criminologists, etc., and what they have to offer. You might want to be looking at supporting more co-op type placements. We do co-op placements for criminology students. It's very successful, and then that of course widens things. I think for professions where people are scarce, and of course we're going into this baby boom retirement where we're going to have a real shortage of professionals. You know, especially physicians are pretty much free agents often, and so there need to be incentives and perhaps, you know, for the kinds of practice that we need, and then disincentives perhaps for the kind of practice that we don't need quite so much of. And you know, that's obviously probably at a provincial level, but I think there needs to be some thought given to how do we move people in these areas, and some of it may be financial as well as training.
I was going to just say, are you talking financial, or are you talking professional development? I know we had one psychiatrist say to us when we were touring, I think it was, I'm not sure it was Kingston or one of the facilities we were touring, saying this is the best lab there is.
Right.
You know, and you could just see the stimulation, the challenges that they were looking at in the stimulation, I suppose, from the practical point of view of what that would mean. So you're meaning on both fronts there?
I am, and you know, I think that is a place to really encourage people. I also think, though, that at a more kind of brunt level of doing the actual clinical work, you know, we would do well to follow some of what's been done in Quebec in terms of CLSCs and getting more and more, particularly with mental health, more and more mental health resources into the community and community health centres and family medicine centres, and giving those people incentives to pick up difficult populations. We're doing some of that, but we could do more.
Now, one thing that I don't think I've heard from any of you today is a peer mentoring system. I'm sure you probably have those systems in place. Does anyone want to comment on that, how effective that is? Because it strikes me what we've heard, if you can develop a peer mentoring system, it is a very powerful tool in the toolbox.
Well, when we talk about peer mentoring, we talk an awful lot about our graduates getting involved with our participants. And so our participants, right now we're in the development of having a meeting every 2 weeks with the participants and graduates that the graduates have actually wanted to do, to talk to them about their problems and to help them out all along the way. And many of our graduates become sponsors and different things in the community for our participants because they keep coming back. They keep coming back to court. It's not unusual to see 1 to 2 to 3 people who are graduating our program in our court every week to support one another.
Right. So it is something that you're developing and see a future in it. Can I take that away from your comments?
Most definitely.
And now, any further outreach that any of you have as suggestions to our committee, and I'm talking about outreach within communities, because you say they're all different, and I concur on that, but any other areas where you can see, you know, as you speak to us, recommendations we can bring forward in terms of how you do the proper reintegration of people with, you know, both addiction and mental health issues. Any comments that way that if you have a wish list?
20 seconds for a response.
Housing is very important. Dr. Ward mentioned there are housing programs available, and it was an understatement when she said there wasn't enough of them. There are way not enough of them, and it's very difficult for somebody to remain clean or maintain their mental health program while living in a shelter system. And so that remains a significant issue that would be of great assistance to us.
Thank you for that.
Thank you very much. Mr. Kenya for 5 minutes. For the 5th round, we should have time to finish the 5th round if we keep everybody to time.
Thank you. Picking up Dr. Ward, we had briefly discussed the fact that the Crown is the gatekeeper. I'd like your comments about that, because to me it would appear that perhaps it should be the judge or somebody else that's the gatekeeper.
I might actually have to ask Mr. Moffat to comment. I mean, I think ultimately the way most of these courts are set up, in the end, the Crown is going to be the one who agrees or who pilots the diversion piece or the favorable legal outcome. We, in mental health court, we don't have a lot of judicial involvement at the front end, and I think it's difficult legally sometimes to figure out how you're going to have that involvement. That's the only comment I have.
The Crown's responsible for public safety. Ultimately, that's what we see as our job. When I started mental health court, the directions that I got from the Crown attorney was, here's the drug treatment court. This is the way it works. Don't ever forget that your number one priority is protecting public safety. And so, as such, the Crown discretion is something that we're just not willing to give up. I mean, that's what we see as our job and our responsibility and our role in the system. So we use our discretion to decide whether someone's screened in or not, and then from there we go with treatment and judges and the rest.
There's a comment here about deemed fit to stand trial in terms of going through the system to make that determination. But this actually, correct me if I'm wrong, I'm not familiar with this system, but that has nothing to do with whether somebody was actually fit at the time they committed the crime, correct? So they could have not been fit at the time they committed the crime,
right,
yet fit to stand trial after the fact, and they
right.
wouldn't be part of this.
And I apologize, I don't know what material you were given. I didn't see it. But there's two different issues. One is the person's mental state at the time of the offense, and that is criminal responsibility related. Right. The second is their fitness to stand trial, which is, do they understand why they're there and what's going on? Very, very basic tests, but they can be completely unrelated. The offense could have happened 2 years ago. They could have been perfectly well, but now they've developed a dementia or psychosis, and they're not fit to stand trial. So they have to be dealt with separately.
Okay. Drug treatment courts. Why the distinction with respect to violence? Because if there are a couple things here. There's the violence, there's the plea of guilty, because I understand that you need to plead guilty in order to have the benefit of this. Secondly, there's a distinction about if you commit a really serious offense, then you don't have the benefit of this sort of rehabilitative program. So, in my view, if somebody's addicted and they've committed an offense, whatever it may be, because of drugs and that addiction, they need help, period. So can you please discuss that?
Well, the starting point is public safety, and the Crown won't screen someone in if we're concerned. This is someone who is in custody now. We're allowing them out of custody to go to treatment, and there's a risk involved. And if there's a risk to public safety that involves violence, then we're less prone to do that. The other instance with the violence is, and this was brought to our attention by the judges, is we're court ordering people to do this, and we're ordering someone to spend time in this program, which in Ottawa is at least 9 months, often 12 months, and if we're going to court order accused to do this, then they have to be in a safe environment, and it's not a safe environment if we're allowing people into that atmosphere where they have committed crimes of violence and are likely to commit crimes of violence again.
So the person that's committed a crime of violence, or it's not even crimes of violence, because there are other more serious, for example, I think break and enter into a residence, you don't get to be part of this program as well, correct?
That's good. There's no drug treatment program in Canada that will allow someone in with a residential break and enter, the exception being, say, a case-by-case basis for a house being built, a new home being built, no one's there, it's a residential home development, then they'll allow people in.
So let's take that non-violent offense. They have a serious drug problem. They cannot go into this program. What do you do to help that individual? Isn't the point rehabilitation to try to make them better so they don't
25 seconds for a response.
For instance, I just had someone not available for drug treatment court talk to the defense counsel and said, not suitable for drug treatment court because of the violence, let's look at other options. Went in with a 2-year conditional sentence, and he agreed to do a 2-year residential in-treatment program followed by 3 years of probation. that was an appropriate sentence, and that was for a series of break-and-enters. So there's the option.
Merci beaucoup, Monsieur Menard, pour 5 minutes.
Thank you very much, Mr. Menard. 5 minutes.
Je voudrais savoir clairement comment vous sélectionnez.
I want to know how you choose the people that are going to be admitted to your program. The individuals decide to apply. So initially, they're the ones that decide. I mean, I do advertise in the sense that I speak to my colleagues and say to them, look out for people who might have addictions issues, who might have mental health issues, and who fit the profile or eligibility criteria. But they are the ones that apply, so we don't do the selection. And then we decide whether we use our discretion at that point to allow them into the program or not. And what would be your eligibility criteria? In Ottawa, and liable to a term of under 2 years, no violence, no crimes, no domestic violence, nothing relating to impaired driving, for instance, no break and entry, for instance. But you do take people who break and enter into businesses, but not into individual households. Yes. So that limits the number of people who could be eligible, right? Yes. At first, it seemed as though you didn't take drug traffickers. I see the difference between those who are doing commercial drug trafficking and others. But in this case, most people who do commercial drug trafficking do use, but a number of them use cocaine. Anyways, it would seem to me that there's not much left. Offenses liable to a term of imprisonment of less than 2 years, there aren't that many of them. At the provincial level in Ottawa, we're somewhat limited indeed. Yes. In any case, are there programs where people would be... do you have residential programs? Yes, well, initially they're not in a residential program, but over time... If our treatment provider believes it would be effective for them to be in a residential program, then they will go into a residential program and then come back into ours. So it would be housing resources. How do you fund these types of resources?
We work with what is available in the community, but we have also managed to arrange some special partnerships with the Homelessness Partnering Secretariat, for example, and partnered with the John Howard Society and the Elizabeth Fry Society to manage supervised transitional housing for our participants. That has been very, very helpful to our program and to our participants. Unfortunately, the funding for that will be coming to an end in March 31st of 2010, and we will have to be seeking other resources to accommodate that.
Sorry, Mr. Menard. I just want to make sure that there's enough time for questions for all members in the fifth round. If you could complete your questioning at this point, or you have 10 seconds left. Yes. I realize that Correctional Services Canada has sent people to Portage and paid for them to get treatment there. Do Correctional Services still send you people?
No. They're not involved with us at that stage because they plead guilty with us. They're guilty pleas, and they're looking at a sentence that could relate to. So they're sentenced after the fact. They're not sentenced right away. They plead guilty right away, but they're not sentenced till after they complete the program.
Thank you. Mr. Davies for 4 minutes.
Thank you. I'll have short snappers here. First of all, dual diagnosis patients. I wonder if you can give me, 45 seconds on the efficacy of this program with people with dual diagnosis.
Now on cognitive delays and impairments with mental health.
yeah, usually mental health and addictions, you know.
Okay, so mental health and addictions. Yeah. Sorry. So, well, I won't comment then because, well, actually, I will comment. We often have people that we would like to see be part of a drug treatment program, but we don't think that with their mental health issues they can manage to handle that program, and we do end up with people from that program who seem to be better served by the mental health court approach.
Okay. Number two, I'm still a little unclear on the violence aspect. I've sort of got three different notes here. One is that people who committed violent offenses cannot participate, or those that have committed violent offenses can, provided they're not at risk to offend or they're not at risk to commit a violent act again, or what? What is the deal on people who've committed an act of violence and their eligibility?
So in mental health court, it's very different. It depends on the court, and we will take all comers pretty much. Drug treatments are different because they're dealing with their federal funder.
Maybe Mr. Brady on drug?
We are, the federal guidelines let us say that we cannot take violent offenders. So that's where our guidelines come from as far as our funding agreements. So that's where it basically rolls down to. We take a look at people on a case-to-case basis. So we don't necessarily exclude them. If it's a one-time thing, if it's something that it's not a history of violence, we may look at them. And what the Crown does in our court, the Crown brings these people to court and say, can you work with them? And we make a decision as a court team along with the treatment team on those bases.
Okay. I'll get just a tad political here, but not to make anybody uncomfortable, but conditional sentences. This government has moved to restrict the availability of conditional sentences. This sounds like this is a poster child program of conditional sentencing. It is, you know, you get a sentence, but you're serving it in the community, in effect, under very tight conditions, drug treatment, etc. Would you agree with me that, at least with respect to mentally ill offenders and people that are addicted, that this types of conditional sentencing are perhaps a better way to go than incarceration?
Just to be clear, drug treatment court is not a conditional sentence. The participants are not under sentence when they come in. Into the program. And I would point out we do have quite a number of participants in our program who are also mentally ill and not faced just solely with addictions problems, though we only have the resources really to be able to work with those who are at the mild to moderate level of
Sorry, can I get you explain that more? I don't understand why that's not a conditional sentence. A person's been charged, they're in court, they either face going to jail or they can serve they can be diverted out of that, however you want to call it. That sounds like, in practice, it is a form of conditional sentence.
In practice, it is very similar to a conditional sentence. And in many ways, I believe it's better than a conditional sentence because we have such consistent monitoring of the participant who's in the program. And the resolution, if there's some sort of a breach, is not simply you're back in jail. Or you get to stay out of jail. There's room to work with modifying their behavior along the way so that the behavior doesn't repeat.
Mr. Moffat, I think did you want to comment on that?
You know what, this is a little close to the political bone, and I would prefer to. I'm very happy with all the tools that the government is giving us, and drug treatment is one of them, and drug treatment works. But I'd say it's very different.
We'll go to Mr. McKenzie now for 4 minutes.
Thank you, Chair. Dr. Ward, and I know you're very young, but I expect from what we've heard that you've got a wide range of experience dealing with forensic psychiatry. One of the areas that certainly as a committee we're wrestling with is, and we hear from the correctional investigator about segregation. Is there a place for segregation in your mind for the extreme end of people with mental health issues short term for protection of themselves and others? Or is there, do you know of something totally different that we have not seen in either Norway, Britain, or here?
You're asking a lot, but thanks for the compliment at the beginning. What I would be advocating for is that there are facilities where, and there's one in Ontario, the Secure Treatment Unit, which is it's a provincial psychiatric hospital within a correctional facility. Now, one of the original proposals I understand was to actually have a remand section for that. And what I would be advocating for is that you need a remand section of a correctional facility which has Schedule 1, like hospital status, so that you can have professionals in there as well doing the treatment. And then if segregation is done, it is done in a medically safe manner with treatment there to essentially address the underlying cause so the person can come out of segregation. That's how I would see it.
My recollection, and I've been in a number of institutions, the psychiatric facilities also have segregated facilities available to them.
Some do, but we don't. Yeah, here in Ottawa.
Oh, okay.
And we deliberately don't, because when you're dealing with a psychiatric issue, you can deal with that person with chemically and physically restraining them and one-on-one supervision, in my opinion, without shutting them in a room by themselves. So we have been able to manage that when we're dealing with mental illness.
And how do you administer then the chemical?
You need to be able to use the provisions under the Substitute Decisions Act or emergency provisions that allow you to act in the person's best interest as their treating physician, and you need the things available to you as a hospital facility to do that legally.
Now, you mentioned there's a correctional facility in Ontario?
Yes, that is a hospital. This is the St. Lawrence Valley Secure Treatment Unit that's in Brockville. It's a provincial facility, but it's our organization runs it, runs the psychiatric piece of it within corrections, and it is actually a psychiatric facility.
Okay. And are you aware of the correctional facility in Saskatoon that has also status?
Yes, and they run it similarly, except that it's one big conglomerate and small pieces of various types of offenders within it. But yes, it's a very interesting model.
Would that equally fit what you're seeing or suggesting with the Brockville one?
They're pretty much equivalent. I've been to both. They're similar. It depends. In Saskatoon, you want economies of scale by putting everything together. Here, we don't necessarily need that because we have larger populations.
Okay, thank you.
Thank you. Two quick matters before we adjourn. First of all, Mr. Davies, I noticed that you have with you today your wife and daughter, so we welcome them to the committee as special guests. The second matter, before we thank the witnesses for their time and appreciate their testimony. Well, actually, let me do that first. Let me thank the witnesses for appearing today. Your testimony was deeply appreciated and no doubt will be invaluable to our production of a study on this matter. So thank you for appearing today. Just quickly before we adjourn, because we have one meeting left before we recess for the Christmas break, and we have one witness who will be appearing on Thursday. It would be my suggestion that we take the last half hour of the meeting on Thursday to tie up any loose ends, leave it open for discussion of future business if committees amenable to that. Committee good with that? Okay, so we'll stand adjourned. Thank you again to the witnesses, and we'll see everyone Thursday.